A sponsor calls about oil rig fund structure in a Regulation D private placement securities offering. The plan is simple. Find a rig, raise capital into one LLC, post the offering online, and pay a friend for investor introductions. That sounds like a simple sponsor capital raise for an oil and gas investment fund. It is not. This is Syndication Attorney Field Notes with Tilden Moschetti. I'm Tilden Moschetti, a syndication attorney. Today's field note is about what has to be built before investor money comes into an oil rig fund. The short answer is this: an oil rig fund is not a financial product you buy off a shelf. It is an engineered legal container. In plain English, the sponsor is selling fund interest to investors. That makes the capital raise a securities offering, not just an asset purchase. That container has to do several jobs at once. It has to create a liability firewall between passive investor money and drilling operations. It has to include tax pass-through drafting if the sponsor wants to support possible pass-through treatment for items like intangible drilling costs or IDCs. It has to choose a Regulation D marketing path before anyone posts about the offering. And it has to be careful about paying people who bring investors. Those are 4 different lanes: entity structure, tax drafting, marketing rules, capital raiser compensation. The common sponsor mistake is treating the fund like a simple deal wrapper. The sponsor sees a physical asset, a rig, a well, a drilling plan. Then the sponsor sees investor demand. Investors ask about yield. They ask about IDCs. They ask how quickly capital can be deployed. That is the investor's view. The sponsor's view has to be different. The sponsor cannot just say we have an oil asset, so we have an oil fund. A fund is a legal container for passive capital. The drilling business is not the same thing as the capital pool. Here is the distinction that matters. The fund is the capital container. The drilling business happens elsewhere. That one sentence drives the structure. The fund holds investor money and investor interests. The drilling operation creates the physical risk. Equipment can fail. A site can have problems. Environmental claims can be expensive. Insurance matters, but insurance alone is not the structure. A liability firewall is the set of legal separations designed to keep those risks in their lane. It is not a promise that no claim can ever cross a line. It is a design choice. You build separate entities, so a problem in the drilling business is less likely to run straight into the passive capital pool or up into the sponsor's main company. A common way to think about this is an LPGP structure. The limited partnership, or LP, is the fund. Investors come in as limited partners. They stay passive. They do not run the rig. A separate GP LLC acts as the general partner. That GP LLC manages the fund role and carries the management exposure. Sometimes there are more layers, but the core idea is simple. Do not put every risk, every asset, every contract, and every investor dollar in the same box. Now take the tax side. Many investors hear oil and gas and think of IDCs. Intangible drilling costs are costs tied to drilling that do not turn into salvageable equipment. Labor, fuel, site prep, and similar costs can fall in that bucket. But the tax result does not pass through just because the fund touches oil and gas. The operating agreement is the plumbing. If the pipes are not connected, the water does not reach the investor. In legal terms, the agreement has to address allocations, capital accounts, and how investor capital is tied to drilling expenses. The documents have to support the argument that the investors actually took the economic risk tied to the possible deduction. The sponsor builds that structure. The sponsor does not promise the tax result. A better way to say it is this: you build the structure. The investor's own tax professional confirms the result. Now the marketing side. Regulation D gives sponsors paths to raise private capital, but the path matters. Under Rule 506B, think private network. No general solicitation, no public post that says invest in this rig fund. This path depends on real relationships that exist before the offer is made. Under Rule 506C, think public marketing with a trade. You can advertise. You can talk about the fund publicly, but every investor has to be accredited, and the sponsor has to take reasonable steps to verify that status. A checked box is not enough. The SEC will hand you a megaphone, but only if you genuinely check IDs at the door. So if a sponsor wants to post on LinkedIn or speak on a public webinar about the specific offering, that choice points toward a 506A analysis, not a 506B habit. Now add one more fact. The sponsor says, I have a friend with wealthy contacts. Can I pay him 5% of whatever he brings in? That may sound like a finder's fee. But a finder's fee is often an unregistered commission wearing a friendlier name. If someone gets paid based on how much investor money comes in, that is transaction-based compensation. In a securities offering, that can raise broker-dealer registration issues. The name on the invoice is not the point. The conduct and the payment method are the point. Let's put this into a quick example. A sponsor forms one LLC called Basin Rig Fund. Investor money goes into that LLC. The same LLC signs drilling contracts, holds the rig interests, pays the operator, and takes in investor subscriptions. Then the sponsor drafts a short operating agreement that says investors may receive oil and gas tax benefits. Then the sponsor posts on LinkedIn opening a new oil rig fund. Message me if you want details. Then the sponsor offers a friend 5% for every investor introduced. That is one business plan, but 4 separate legal questions. First, the entity structure may be too flat. The fund and the drilling risk are in the same box. Second, the tax language may be too thin. IDCs may be possible, but the agreement has to support the pass-through. The label does not do the work. Third, the LinkedIn post may be public marketing. If the sponsor is relying on Rule 506B, that can move outside the private network path. If the sponsor chooses Rule 506C, then verification becomes part of the process. Fourth, the 5% payment may be transaction-based compensation. That can create a broker-dealer question, even if everyone calls it a referral fee. None of this means an oil rig fund cannot be structured. It means the order matters. Structure first, then documents, then marketing path, then capital raiser compensation, not the other way around. Here is what not to assume. Do not assume one LLC plus insurance is enough to isolate drilling risk from investor capital. Do not assume IDCs pass through to investors just because the deal involves oil and gas. Do not assume other sponsors' public posts mean your Rule 506B offering can be public too. Do not assume Rule 506C lets you advertise and then skip investor verification. Do not assume calling a payment a finder's fee solves the broker-dealer issue. And do not assume a liability firewall is absolute. It is a risk-controlled design, not a force field. The field note is this: an oil rig fund lives or dies on legal engineering before the pitch. The investor may focus on yield and tax benefits. The sponsor has to focus on structure. Labels do not control outcomes. Calling it a fund does not create separation. Calling a payment a finder's fee does not remove the broker-dealer analysis. Calling a deduction available does not make it reach the investor. The structure, the documents, the Regulation D marketing path, and the compensation arrangements do the work. The engineering happens before the first dollar comes in.